Hello, everyone, and welcome back to Criminal Law 2, Substantive Criminal Procedure and Substantive Criminal Law. Today, we're discussing non-principal liability, right? So when we talk about a principal, generally speaking, we're talking about the person who physically commits the crime. So today, we're looking at people who are not necessarily the ones who commit the act itself, but are somehow involved. So let's jump in. Okay, so let's begin with this idea of complicity. So complicity establishes when you can be held criminally responsible for someone else's conduct. Right, so it might not necessarily be your conduct, but because of your involvement or because of maybe a special relationship, you can be held criminally responsible for somebody else's actions. Now, there are four types of common law parties to a crime. So we have principals in the first degree, principals in the second degree, accessories before the fact, and accessories after the fact. And this is in descending levels of severity. So let's go through them. All right, so let's think about this way. Principal in the first degree, at least under the common law, was a person who actually commits the crime, right? So if we're thinking about a bank robbery, right, this is the guy who goes inside, pulls out the gun, and robs the bank, right? He's the principal in the first degree because he's the one who committed the crime, right? Now, complicity isn't needed here because he's not being held responsible for someone else's conduct. He's being held responsible for his own conduct. Then the second most severe type of really criminal responsibility is, or excuse me, are principals in the second degree. And this is where a person is present when the crime is committed and who helped commit it. All right, so a person is present when the crime is committed and they helped commit it. So the way to think of this is the person didn't actually do the main offense, but they contributed to that offense. So this would be in our bank robber example, the getaway driver, right? So the car pulls up in front of the bank. The principal in the first degree gets out, runs in the bank with a gun, robs the bank. The principal in the second degree is sitting in the driver's seat right near the door, ready to speed off as soon as the guy gets out with the money. Now, theoretically, they aren't as complicit as the person in the first degree, but they can be held responsible for the person who robbed the bank's actions. And we're going to talk a little bit about why that is in a minute. Then we have, and we distinguish between principals in the first degree and principals in the second degree to accessories. Right? So there's accessories before the fact, and there's accessories after the fact. An accessory before the fact, basically a person is not present during the crime, but helped before the crime was committed. Right? So, and we'll talk about this in a little bit, but just being present at the scene of a crime does not make you complicit. Right? There has to be some type of shared mens rea. There has to be some type of shared common goal. Now, accessories before the fact, you weren't there when the crime was committed, but in a way you did help commit the crime because in our example, you supplied an instrumentality to commit the crime. So, but for your conduct, the crime could not have been committed. So think about the person who's supplying the weapon to the robber, right? So this is different than just if you go to a gun show and you decide to buy a gun, no questions get asked, right? But if you are trying to buy a handgun on the black market and you tell somebody of your plan to rob the bank and they're like, oh yeah, well, this is gonna be the best gun to rob that bank with. And here, I'll sell it to you. They're an accessory before the fact, right? So before the crime has actually been committed, but they are doing actions in furtherance of that crime. And then we have accessories after the fact. Now, this is still a very serious position to be in, but it is the least severe when it comes to complicity. So accessories after the fact are persons who help after a crime is committed. Now, generally speaking, they usually are not present, right? So that's how we distinguish between a principal in the second degree and an accessory after the fact. So a person who helps after a crime is committed. So this is after the principal, the bank robber, gets into the car with the principal in the second degree, the getaway driver, and they drive to their grandmother's house. And they tell the grandmother exactly what they did. And she says, "Oh, come on in, hide in the basement." At that point, grandma has become an accessory after the fact because she helped after the crime was committed, right? She helped harbor the fugitives, the fugitive robber and the getaway driver, from authorities, right? So now there's usually no duty to call the police or anything along those lines, but let's say police came by and said, "Have you seen them? Are they here?" All that stuff, and she lies to the authorities. Then we definitely have an accessory after the fact type situation. Now, those can get complicated. So we have a more modern rule, all right? So our modern rule provides that there's only two parties to criminal complicity. So we do have principals, all right? But instead of and again, it helps us distinguish between the person who committed the crime and those who assisted, right? So the modern rule provides there's only two parties to criminal complicity. Again, complicity is being held responsible for someone else's conduct. So we have accomplices and accessories. And again, this is the more modern rule. So accomplices participate before and during the crime, right? So under the old common law, they would be principals in the second degree, and generally speaking, accessories before the fact. So those are accomplices, right? They participate before or during the crime. And that's kind of generally what we think about when we think about an accomplice. Then we have accessories. Accessory is a participant after the crime is committed, right? So this would be an accessory after the fact. We just call them accessories. So we have principals, we have accomplices, we have accessories, right? And when we're talking about complicity, definitionally speaking, we're talking accomplices and accessories. So going back to our example, the person who sold the bank robber the gun, knowing that it was going to be used in the commission of a bank robbery, as well as the getaway driver, are accomplices. Grandma is an accessory, right? So again, the person who sold the bank robber the gun and the getaway driver, they participated before the crime, so selling the gun, or during the crime, right? So during the getaway phase. And an accessory would be somebody who participated after the crime was committed. So this was grandma. She wasn't present, she wasn't there, but she helped further the crime after the crime had been committed. So one really important thing to note is accomplice and accessory liability differ from what's called vicarious liability. So in vicarious liability, a party can be held liable not because of their participation in a crime, but because of a special relationship that exists. So when we think of special relationships, some of them more common, and this is more common in civil lawsuits as opposed to criminal cases. we think of employee-employer, right? So if you commit a tort, if you commit a civil wrong while you are working in your capacity for your employer, and let's say you injure a customer, right? Like, let's say that you are at a grocery store and you see water spilled, but you don't clean it up, you don't put a sign over it, or maybe you spill water on purpose, hoping somebody will trip, right? Then we have old lady walks down the aisle, slips on the water, cracks her pelvis, right? The lady can sue the employee, but you always want to go for the deepest pockets. So the lady could sue the employer, right? Because basically vicarious liability is, yeah, you didn't do it, but because there was a special relationship there, you were responsible for supervision, you were responsible to ensure that the person did their job, followed procedures, etc. In that case, we're going to say that the employer can be held responsible as well. Now, there's also the parent-child relationship. So the parent-child relationship is actually a fairly interesting one, because when we're talking about the parent-child relationship, again, usually we're talking about this in the context of civil lawsuits. It can occur in criminal lawsuits, but this comes into play in criminal lawsuits or criminal suits or even civil lawsuits when we hold a parent legally responsible for their child's conduct, right? So this is just speaking if they're under the age of 18, or they're under the age of the majority in the state, child commits a crime, and depending on the nature of the statute and whatnot, you can hold parents responsible for the crimes their child commits. Now, remember we've discussed about in the law, generally speaking in the United States, if you are under the age of 7, you are considered incapable of committing a crime, right? So basically you're incapable of forming the mens rea or the mental state needed to commit a crime. If you're over the age of 7, then you can commit a crime, and the question becomes, who's responsible? Is it the parents? Is it the kid? What's going on here? Now, this is a lot easier to answer in civil lawsuits, right? So civil lawsuits, vicarious liability is very much a thing. And in civil lawsuits, we can hold generally a child responsible for their actions, regardless of how young they are. But ultimately, it's the parents who have to pay out the money, the damages that result. All right, so think of it this way. There's a really famous case where a child, that there's this kind of like backyard barbecue or whatever, and there's a child, and the child's a little mischievous, and so they're all kind of like sitting down at this picnic table or this table with chairs, and this lady is about to sit down, and the child pulls the chair out from under her, right? So she, instead of sitting on the chair, she collapses to the ground, and she gets injured in the process. Now, in this case, the court held that ultimately the injured party had the right to sue the child. So even though what the child did was technically also a crime, there wasn't criminal charges pressed, but in this case, they were dealing with a civil lawsuit. They said that, yeah, the child could be held responsible. But that being said, because the child was under the age of majority, then the parents are the ones who are ultimately responsible for the damages. So this, again, this is the idea of holding somebody else accountable. Another kind of example that we have is a buyer-seller relationship. a producer-consumer relationship, a service provider and recipient relationship, etc. Now, if you want to think about this kind of in a little bit more easy context, think of it this way. Okay? So vicarious liability can arise out of other situations. So let's say you own a vehicle, right? And you decide to loan it to your best friend. Their car's in the shop, whatever, you loan it to the best friend. Well, your best friend, while driving out and about, and there's no one around, runs the red light. And there's no trooper, no police officer around to see it, but the traffic light has a camera, right? So when your friend runs the red light, it takes a picture of your license plate. And then in the mail, you get a ticket. That ticket is going to be in your name, not your friend's name. It's going to be in your name because you owned the vehicle. And it gets really difficult to figure out like who was driving and all that jazz, especially when it's not really that serious. So it's going to be in your name. Now, you can always sue your friend, but generally speaking, when you loan your vehicle to somebody, you are basically telling them in the outside world that you are taking active responsibility for anything that happens, any tickets, any fines, anything that occurs from the use of that vehicle, because you're the one who entrusted the other party with it. Now, there are two policy reasons for accomplice and accessory vicarious liability. So these are kind of our abstract notions of why we can hold people responsible as accomplices or accessories or even vicariously liable. We have two theories. We have agency theory, and then we have forfeited personal identity theory. So agency theory is this notion that we are autonomous agents who should be held responsible when we choose to engage in someone else's conduct. Right? So we have a choice whether or not to engage in somebody else's conduct. So if somebody says, I'm going to rob a bank, do you want to help me? Well, this theoretically implies that we have rational choice, which most crimes aren't rational. So that's kind of a difficult argument to make. But it basically says that we can say yes or we can say no. And the fact that we said yes will help should mean that we get held responsible for what happens. Now, this is a little bit more difficult in criminal cases where, let's say you have somebody who comes to you and says, I'm going to rob a bank. Are you in? And let's say you don't want to be in. Like you're just like, no, I am not. But the person has a weapon, right? And you're scared that the person who just told you they're going to rob a bank, if you don't help them, they're going to hurt you. Well, then we still have agency theory because you chose to engage in somebody else's actions, but a affirmative defense, which we'll cover later in this course, an affirmative defense might be appropriate. An affirmative defense basically is where you say, yes, I committed the crime or I helped commit the crime, but I only did so because I was under duress or there was some kind of justification or some kind of excuse, something along those lines. And the other theory we have, the other reason that we have for holding people responsible for other people's conduct is the forfeited personal identity theory. And what this basically says is when you choose, and again, there's that rational choice coming into play that most crimes aren't rational, right? Or else they wouldn't be committed. But we assume under the law, at least American law, that you make a rational choice to commit a crime, right? You make a pros and cons list and you decide to commit a crime. So when you choose to participate in a crime, you forfeit the right to be treated as an individual, right? So when you choose to commit a crime and you commit it with somebody else, you no longer get to be treated as your special self, as just what you did. It's you joined up with this other person, so you forfeited your personal identity, right? Instead, the two of you or the three of you or the four of you or the five of you or however many of you had a collective identity, right? So you were all acting as one person, as opposed to separate individuals. And since you were all acting as one person, you have to be held responsible as that single person. So we'll talk about accomplice liability, right? We have equations here as well. So accomplices, remember, they are participating before or during the crime. This is the more modern rule. They are prosecuted for the crime itself and may be subject to the same punishment. Right, so this is somebody who supplies the weapon before, knowing that's going to be used in the commission of a bank robbery. This is somebody who was present at the scene of the crime but didn't commit the robbery, but had the actus reus, the mens rea, in any attendant circumstances required to be held liable as an accomplice. So just because you sell somebody a gun and then they go rob a bank, but it doesn't necessarily mean that you're going to be held responsible. But if you know that you are selling them a gun so they can go rob a bank, you are participating before the commission of the crime. So you are an accomplice. And not only can you be held responsible for any firearms offenses that you may have committed, but you can also be held responsible for the bank robbery. We can charge you with the bank robbery. Now, in a later class, we'll talk about conspiracy and what all gets involved in conspiracy and how you charge co-conspirators and all that stuff, especially under RICO and different things like that. But generally speaking, you can be prosecuted for the same crime that the principal commits if you participated before or during the crime. And you can be subjected to the same punishment. Right, so if the bank robber gets 10 years in prison, you can be charged, if you sell the gun, you can be charged with bank robbery and sentenced to 10 years in prison. Because again, we kind of with accomplices say that they're kind of acting as the most complicit, right, as opposed to accessories. So that being said, in order to show that somebody has accomplice liability, in order to prove it, again, we have to prove this beyond and to the exclusion of all reasonable doubt. We have to start with where we always begin, the actus reus. Right? So the actus reus is either aiding, abetting, inciting, or encouraging another to commit a crime, or presence at the scene of a crime when there's a legal duty to intervene. So let's break this down. Let's begin with number one, aiding. So giving assistance, abetting, again, helping and hiding, inciting, so encouraging others to commit a crime. And again, encouraging, same thing as basically inciting, is getting them fired up to actually commit the crime. That's enough, right? That's the actus reus. So what we have right now is really an interesting scenario, because this is kind of what we're talking about, at least when this is 2021, when this is being recorded. Right now, they are having the second impeachment trial of former President Donald Trump for what they said was inciting an insurrection at the U.S. Capitol building. Right, so the actus reus, we'd have to show, right, they aided, they abetted, he aided, he abetted, he incited, or he encouraged somebody else to commit a crime. Now, encouraging is, I want you to do this specific act. Inciting is, I create the environment and I create that kind of fire inside of you to commit that act. So that's the actus reus, right? And again, this, you can debate politics on this either side, but that's what they're talking about when they're talking about inciting, right? It is basically creating the environment, knowingly creating the environment in which a crime is going to occur. Then we still have to prove mens rea, right? Because this is a required element in any attendant circumstances that are present, and we'll address each of those in turn. Now, as I've said before, generally speaking, there is no duty to intervene, right? So you do not have a duty to call the police if you see somebody being murdered, unless you have some kind of special relationship, you're a mandated reporter, let's say of child abuse or something along those lines, then you have a legal duty to intervene. Now, what becomes interesting is police officers, right? So let's say that you go into a bank, there's a police officer, and let's say for our purposes, he's on duty and he's in the bank as well. And but he's an undercover officer, right? Like he's plain clothes. So the suspects don't pay any attention to him. The bank robber doesn't pay attention to him. He's present at the scene of the crime. And generally speaking, as an officer of the law, you have a duty to intervene and stop a crime, right? Because again, there's a special relationship, there's a special kind of impetus imposed upon law enforcement. We don't want to have a rule where we say, well, if the police see somebody committing a crime, they can be like anybody else. They don't have to get involved. No, that's quite literally their job, right? So this is where accomplice kind of comes into play. Is, let's say you had no idea about the robbery, but you were present at the scene and you were an officer of the law, so you had a duty to intervene, but you didn't. Well, that could be enough. Remember, an omission is also an act. That could be enough to get us the actus reus for accomplice liability. Without getting into mens rea, which we will in a second, you can think about this when we think about the Parkland shooting, school shooting in Florida, where the officer was out on the scene, but basically cowered out, didn't go in to save people's lives, stayed outside, he's been charged with child neglect, child endangerment, things like that. But theoretically, if he meets the mens rea in the intent circumstances, we could say he's an accomplice to the murder of those students, right? Because the officer was present at the scene of a crime, and the officer had a legal duty to intervene. So theoretically, we could charge, remember, for accomplices, we can charge them with the exact same crime, and they can reserve the exact same punishment. So Florida is a death penalty state. All right. So if we charged, let's say we charged the shooter with first degree murder and they get the death penalty, well, the officer who was at the scene of the crime, again, assuming the mens rea is there, could also be charged with first degree murder and receive the death penalty. Now, that being said, that's not all to our equation. And this is where we're going to see where things change. Mens rea has to be present. Now, there's a majority rule and there's a minority rule. So the majority rule, most states adopt that intent to commit the actus reus has to be present. So you purposefully or you knowingly committed the actus reus. Or, and this is the minority rule, you had intent to commit the crime itself. So you purposefully or knowingly committed the crime or allowed the crime to happen. And then we have any attendant circumstances that the individual statute requires that you have to meet. So if we kind of harken back and we look at the insurrection at the Capitol, you could make an argument that there was inciting, especially when you hear the day of speeches and martial law and taking law into your hands and things along those lines. It could create the environment where people will go out and commit insurrection, right? It could. But then we get to the mens rea. Now, the mens rea is the interesting part, because for the mens rea, you'd have to prove that former President Trump or his personal attorney and former mayor of New York City, Rudy Giuliani, acted with purpose or knowingly to commit the actus reus, right? So they intended to incite the mob into mob violence, into insurrection. If they just did so recklessly or negligently, well, then we don't have enough here to meet accomplice liability under the majority rule. right? So if we think about the Parkland shooting, and we'll talk about the officer's presence at the scene, right? Did the officer purposefully and knowingly not intervene when he had a legal duty to intervene? I think the clear answer here is absolutely, right? The officer is getting off fairly easily because he intended not to act because he stayed outside. Like it wasn't like he was waiting for backup recovery. Like he had a legal duty to go in and save lives, and he didn't. And his intent was to purposefully not go in. Now the question is, was it not to go in and save lives? I mean, there kind of gets a little tricky, but it's a really kind of interesting scenario. Now, that being said, if we look at both the insurrection and we look at the Parkland shooting, under the minority rule, there has to be intent to commit the crime itself, right? So the idea here is you purposely or knowingly committed the crime. So this is insurrection. You incited them and you knowingly wanted them to be incited to commit insurrection, right? You wanted an insurrection to occur, you wanted mob violence to occur, etc. Presence at the scene, again, the minority rule is you wanted the shooting to occur. Now, again, the insurrection, it's more of a political question, but there is some really interesting legal aspects to it. But with the Parkland shooting, it's really difficult under a minority rule to say that the officer's purpose in not going in, or the officer knowingly not going in, basically their intent was for the shooter to commit murder and shoot students. Right. So under the minority rule, it's a little bit more difficult, but under the majority rule, an argument can be made. That being said, we also have to have any attendant circumstances. So anything that the statute requires. Remember, that's where we start. We start with the statute. We label the elements of a statute, and we say, okay, everything in the statute has to be proven beyond and to the exclusion of all reasonable doubt. Now, this differs from conspiracy, right? Accomplice liability differs from conspiracy. Conspiracy is the agreement to commit a crime. Because accomplice liability requires that you participate in some way in the actual crime itself. Whereas conspiracy, under the Pinkerton Rule, the crime of conspiracy and the crime the conspirators or co-conspirators agreed to commit are separate offenses. So that's why you can charge somebody with conspiracy to commit murder, but the murder never actually occurred, right? If parties agree fully intentionally that they are going to commit murder, that's a crime, right? Conspiracy in and of itself is a crime. And let's say they agree to commit murder and then they go out and commit the murder. Well, they've actually committed two crimes, right? They've committed conspiracy, and specifically in this case, conspiracy to commit murder, and then they've committed murder, right? So again, this differs from conspiracy. Conspiracy, you don't have to participate in the crime, right? So it's like, oh yeah, we should all do this. Oh yeah, I agree. We're going to commit this crime. And then maybe you check it out at the last minute. Too bad, right? You've committed conspiracy. You've agreed, you've planned, you've discussed, you've committed the crime. Now, you may not have committed the actual crime itself, and we'll talk about conspiracy and RICO and how you can get basically everybody who participates for the same crime. But conspiracy doesn't require participation in the actual crime, whereas accomplice liability does require participation in the actual crime. So that being said, we kind of mentioned this a little bit ago, but there is such a thing called the mere presence rule, right? And so a person's presence at and flight from the scene of a crime are not enough to satisfy the actus reus requirement of accomplice liability. So from this kind of perspective, right? Um, this is the notion that, um, you know, let's say bank robber goes into a bank and pulls out a gun. You're technically at the scene. You're just in line as a customer. You're at the scene, and you take running. As soon as you see that gun, you take off running out the damn door. That's the mere presence rule. You were just present when the crime occurred, right? You had, again, there was really no mental state to ensure that crime was furthered. So if we take a look at a couple of cases, there's some interesting ones on point. So for example, there's Bailey versus United States, which is a 1969 case. In this case, the person in question, Bailey, spent most of the afternoon shooting craps with another man. Then when a man carrying cash walked by, Bailey's craps partner pulled a gun and robbed the man with the cash. Both Bailey and his craps partner fled from the scene. Bailey was caught, but his partner never was. The court held that, although flight from the scene of a crime can be taken into account, it's not enough to prove actus reus. Right? So, according to the court, and this is a really great quote, we no longer hold tenable the notion that the wicked flee when no man pursueth, but the righteous are as bold as a lion. I love that line. Right? It's the idea of like only guilty people run. Well, that's not true, right? It's not true at all. I mean, think about what has to be happening. These guys, they're playing a game of craps, and guy walks by with cash, and this other guy gets up and robs him. Like, you're just in a state of panic. Like, you had no idea what was going on. You didn't help aid and abet. You just were like, what the hell? And when the other guy takes off, you're just like, you get terrified and you flee. Well, that's Bailey versus United States, right? Here again, there is no duty to act. There's no duty to legal duty to intervene. And the idea here is not just guilty people run, innocent people run too, because again, the sheer terror, the unexpected nature of it, etc. The idea of like, if you're not guilty, you're going to stand there as bold as a lion. No, because what if the guy has a gun? What if the guy's pissed off? Like, and you're just sitting there like, what the hell? And then he pulls the gun on you. So again, there are some problems associated with that. We also have State v. Walden. So State v. Walden, there's this kind of this exception to the mere presence rule, right? And as I said before, when a defendant has a legal duty to act, presence alone is sufficient to satisfy the actus reus requirement. So again, this is kind of that Parkland shooting idea. So in State versus Walden, George Hoskins beat Alan Walden's one-year-old son, Lamont, quote, repeatedly over an extended period of time with a leather belt until he was bloody. Walden looked on the entire time the beating took place, but did not say anything or do anything to stop Hawkins from beating Lamont or otherwise deter the conduct. So here's what a jury found. The jury found that Walden was an accomplice to the assault. On appeal, the Court of Appeals said that the trial court had properly allowed the jury to consider a verdict of guilty of assault upon a theory of aiding and abetting solely on the grounds that the defendant was present when her child was brutally beaten. A person who aids or abets under another in a commission of a crime is equally guilty with that other person as a principal. Right, so State v. Walden, basically she saw like this guy beating the crap out of her kid, and she just, with a leather belt, and kid's bloody, and she's just watching. Parents have a special relationship, right? We've discussed that. So parents have a special duty to act. They have a duty to intervene. Now that brings us to the next case, State versus Levine. So in this case, Levine was convicted of first-degree murder, which imposed criminal liability on one who, quote, intentionally aids, advises, hires, counsels, or conspires with or otherwise procures another to commit a crime. Right, so ultimately what happens in this case is the Supreme Court of Minnesota reverses the case. But what happens is Carol Hoffman, Levine's daughter-in-law, was murdered late in the evening of August 10th, or very early in the morning of August 11th, by her husband, David Hoffman. She and David had spent an amicable evening playing with their children, and when they went to bed, David wanted to make love to his wife. When she refused him, he lost his temper and he began choking her. While he was choking her, he began to believe he was, quote, doing the right thing. And to get, another quote, the evil out of her, he had to dismember her body. So after he kills his wife, David calls down to the basement to wake up his mother. The mother's living in the basement, asking her to come upstairs and to sit on the living room couch. From there, she would be able to see the kitchen, the bathroom, and bedroom doors, and could stop the older children if the older child, if she awoke and tried to use the bathroom, right? So basically, hey mom, I just killed my wife. Can you, keep an eye out why I dismember her, right? I mean, that's basically the crux of this case. And so ultimately, he dismembers the body, puts it in the bags. Then Hoffman cleaned the bathroom, took the body to a lake, disposed of it. When he returned home, he told his mother to wash the cloth covers from the bathroom toilet and tank, which she did. Then David fabricated a story about Carol leaving the house the previous night after an argument, and Helen agreed to corroborate it. David phoned the police with a missing persons report, and during the ensuing search and interviews with the police, he and his mother continued to tell the fabricated story. So ultimately, David ends up confessing, right? And Levine's relationship with her daughter-in-law was a strained one. So she was kind of acting as like a live-in babysitter to the two children, and she wasn't happy about having the daughter-in-law wasn't happy about having Levine move in, and told friends that she hated her, and that she told both David and his mother they could try an arrangement to see how it worked. So she gave in a little bit. On the morning of the murder, Helen told her son, so the mother told her son, that she was going to move out of the residence. Carol had been so nasty to me. In his statement to police, David reported the conversation the morning as follows, and there's this really great Q&A quotes. And again, it's the idea of basically, hey mom, I committed a murder. Can you make sure that the kids don't come in while I dismember the body? And then we're going to tell the police this is what happened. And again, ultimately, David ends up confessing. So she gets charged with the murder as well. And because of her cooperation with her son, she insinuated by statute from guilt as an accomplice after the fact for such conduct because of her relationship as a parent of the offender. Now, to this end, right, there was a Minnesota statute on point, and what it did is it said that the jury might well have considered Levine's conduct in sitting by while her son dismembered his wife so shockingly that it deserved punishment. Nonetheless, these subsequent actions do not succeed in transforming her behavior prior to the crime to active instigation or encouragement, which implies a high level of activity on the part of the aider and the abettor in the form of conduct that encourages another to act. So the statute uses terms such as aids, advises, and conspires, requires something more of a person than mere inaction to impose liability as a principle. Right? So basically in this case, they were saying like, okay, yeah, she's a piece of crap. Like she's a very bad person. But she did not aid or abet prior to the actual act itself occurring, right? Or during. The only time that she got involved was after. And once you get involved after, then generally we're not going to hold you to the same level of accountability and responsibility as if you were the person who did it or was involved during the commission of it. So there's where State versus Levine kind of comes into play. It kind of draws that line as to the difference between accomplice and accessory. That being said, there's a couple cases on point that deal with accomplice mens rea. So we have Blacken versus United States. So in this case, Blacken sold silver to Zucker. Silver knew that the silver was stolen. Zucker knew the silver was stolen, but Blackham didn't sell the silver on purpose of sharing any profits with Zucker. Still, according to the court, knowingly selling the stolen property was good enough. Guilt depends not on having a stake in the outcome of a crime, but on aiding and assisting the perpetrator and those who make a profit by furnishing to criminals, whether the sale or otherwise, the means to carry on their nefarious undertakings, aid them just as truly as if they were an actual partner, having a stake in the fruits and the profits of the crime. Right. So again, in this case, it was this idea of, just because he didn't stand to profit didn't mean he didn't aid and abet because he bought the silver. He knew it was stolen. Like he helped. Like without him, like the commission of selling stolen goods or receiving stolen goods couldn't have happened. Right. And then we have a great case, United States versus Pioni. So in Pioni, it's really cited over and over again as defining mens rea of accomplice liability. Now, basically what happens is in a 2002 survey of only federal court cases, Assistant U.S. Attorney Weiss cited a few examples illustrating the confusion. So here's some answers and questions. It's simple knowledge enough, right? So if you look on page 251, there is a very like a long case of like courts going back and forth discussing whether or not accomplice mens rea is really as simple as articulated in Pioni. So basically what happens in Pioni is there's this enormously respected judge. His name, and if you go to law school, you'll hear it time and time again, his name is Learned Hand. Like legitimately, that's his real name, is Learned Hand. So Judge Learned Hand gets to deal with the case of Pioni. So Joseph Pioni sold counterfeit money to Dorsey in the Bronx. Dorsey was caught trying to pass the fake money in Brooklyn. Pioni was indicted as an accomplice to Dorsey. At the trial, the prosecutor relied on the words aids, abets, counsels, commands, induces, or procures. Under the United States Criminal Code's accomplice statute, the prosecution argued that Pioni knew Dorsey possessed counterfeit money and that knowledge was enough to convict him. The jury convicted Pioni, but on appeal, Judge Learned Hand didn't accept the prosecution's argument. According to Judge Hand, if somebody or if someone was suing Pioni for damages, knowing that knowledge would be good enough. This is a criminal case where all the words in the statute demand that he in some sort associate himself with the venture that he participate in and is something that he wishes to bring about, that he seeks by his actions to make it succeed. All the words used, even the more colorless abet, carry on implications of purposeful attitude towards it. Right, so think about what happens in this case, right? You have Peony who sells Dorsey counterfeit money. Dorsey gets busted, and then they try to pin the use of the counterfeit money back on Peony as well. And they said, well, Judge Learned Hand was like, no, right? He just knowledge is not enough. But if you look at page 251, this question of is mere knowledge enough? You have yes, says the Supreme Court in 1870. No, says Judge Learned Hand in 1938. Yes, says the Supreme Court in 1947. No, says the Supreme Court in 1949. Yes, if it's accompanied by an act that substantially facilitates the commission of the underlying offense, says the Supreme Court in 1961. Usually, said the Second Circuit in 1962. Only if knowledge is enough for the underlying offense, said the Second Circuit case in another 1962 case. Sometimes, said the Seventh Circuit in 1985. Always, implied the Seventh Circuit in 1995. No, said the Second Circuit in 1995 and the Seventh Circuit in 1998. So this question of is mere knowledge enough, right? And again, if we have Levine, like she had knowledge of what happened, but did she, again, act as an accomplice, right? Did she act prior to or during the commission of the crime? No, she acted after. So she acted really as an accessory, right? To that end, she could be charged with something along the lines of decimating human remains, right? So when her very, obviously sane and well-behaved son was dismembering his wife, and she could see it and she knew it, and then she helped clean it up, well, that case, she was an accomplice to the desecration of human remains. But she didn't know, nor did she do any act or anything along those lines in terms of the actual murder itself, right? Before or during. Instead, all of her actions took place afterwards. Because they took place afterwards, and because mere knowledge is not usually enough, she's not an accomplice. Instead, she is an accessory, which again carries a much lower sentence, a much lower penalty, and her conviction was ultimately vacated. So let's move on to accessory liability. So accessories, they're participants after the crime is committed. Now, accessories are generally treated as a secondary crime, right? So they're a separate crime. And usually, if you're an accessory, it's going to be a misdemeanor offense, right? So for the actus reus, which is required, you have aiding a felon to avoid arrest, prosecution, or conviction. The mens rea is your purpose or your knowledge or knowingly acting to aid a felon to avoid arrest, prosecution, or conviction. And then any attendant circumstances required by the statute. So if we look at Levine, in this case, he committed several felonies. Did she aid the felon to avoid arrest, prosecution, or conviction? Yes, right? She cleaned the bathroom, she lied to the police, etc. Was it her end goal? Was it her purpose to aid that felon from avoiding getting arrested, prosecuted, or convicted? Yes. All right, so this is where Levine is actually an accessory, not an accomplice. So a great case on point is State v. Chisholm. State v. Chisholm is a very sad case because somebody dies, but it is a wild case. It is just holy cow. So we have somebody who I is they say impersonating a female. So we have somebody who probably identifies as female, who is biologically assigned, or who is assigned the gender of male at birth. We have a one-legged uncle who loses his leg at some point during this offense. It's a great case. So let me just briefly read to you the facts, and then we can discuss it. So on the evening of August 26, 1981, in Shreveport, this is Louisiana, Tony Duke gave Brian Chisholm a ride in his automobile. Brian Chisholm was impersonating a female, and Duke was apparently unaware of Chisholm's disguise. After a brief visit to a friend's house, the two stopped to pick up some beer at the residence of Chisholm's grandmother. Chisholm's one-legged uncle, Ira Lloyd, joined them, and the three continued on their way drinking as Duke drove the automobile. When Duke expressed a desire to have sexual relations with Chisholm, Lloyd announced that he wanted to find his ex-wife Gloria for the same purpose. Shortly after midnight, the trio arrived at St. Vincent Avenue Church of Christ and persuaded Gloria Lloyd to come outside. As Ira Lloyd stood outside the car, attempting to persuade Gloria to come with them, Chisholm and Duke hugged and kissed in front seat as Duke sat behind the steering wheel. Gloria and Ira got into an argument, and Ira stabbed Gloria with a knife several times in the stomach and once in the neck. Gloria's shouts attracted the attention of two neighbors who unsuccessfully tried to prevent Ira from pushing Gloria into the front seat of the car alongside Chisholm and Duke. Ira Lloyd climbed into the front seat also, and Duke drove off. One of the bystanders testified that she could not be sure, but she thought she saw Brian's foot on the accelerator as the car left. Lloyd ordered Duke to drive to Willow Point near Cross Lake. When they arrived, Chisholm and Duke, under Lloyd's direction, removed Gloria from the vehicle and placed her in some high grass on the side of a nearby roadway and a wood-lined roadway. Ira was unable to help the two because his wooden leg had come off. Afterwards, Lloyd requested the two drive off, leaving Gloria with him. There was no evidence that Chisholm or Duke protested, resisted, or attempted to avoid actions which Lloyd ordered them to take. Although Lloyd was armed with a knife, there was no evidence he threatened either of his companions with harm. Duke proceeded to drop Chisholm off at his friend's house, where he changed into male clothing. He placed the bloodstained woman's clothes in a trash bag. Afterwards, Chisholm went with his mother to the police station at 1:15 a.m. He gave the police a complete statement and took the officers to the place where Gloria had been left with Ira Lloyd. Police found Gloria's body in some tall grass several feet from that spot. An autopsy indicated the stab wounds that caused her death. Chisholm's discarded clothing disappeared before the police arrived at the trash bin. So ultimately, Brian Chisholm is convicted in this specific parish in Louisiana of being an accessory after the fact. And he was sentenced to 3 years in the parish prison with 2.5 years suspended. The defendant appealed. The Supreme Court of Louisiana affirmed the conviction, but vacated the sentence and remanded the case for resentencing. So the statute that really comes into play here is Louisiana Statute 14, subsection 25, which states in part, an accessory after the fact is any person who after the commission of a felony shall harbor, conceal, or aid an offender knowing or having reasonable grounds to believe that he's committed a felony, and with the intent that he may avoid or escape the arrest, trial, conviction, or punishment. Whoever becomes an accessory after the fact shall not be fined more than $500 or imprisoned with or without hard labor for not more than 5 years, or both, provided that in no case shall his punishment be greater than one half of the maximum provided for the principal offender. So again, here we have Chisholm. He appeals his conviction as sentence, and he says basically that the defendant assigned error that they have to determine whether in the evidence in the light most favorable to the prosecution, that any rational trier of fact could have found beyond a reasonable doubt that one, a completed felony had been committed by Ira Lloyd before Brian Chisholm rendered him the assistance. Two, Chisholm knew or had reasonable grounds to know that the commission of a felony by Lloyd occurred. And Chisholm aided Lloyd personally under circumstances that indicate either that he actively desired that the felon avoid or escape arrest, trial, conviction, or punishment, or that he believed the one of these consequences and subsequently certain to result from his assistance. Now, in this case, they kind of go through and they do an analysis, and they ultimately say, look, Chisholm didn't protest. Chisholm didn't try to leave the car when his uncle Lloyd shoved the mortally wounded victim inside. He did not attempt to persuade Duke, his would-be lover, to exit out of the driver's side of the vehicle. He did not take and flee from his uncle, who he knew had only one leg and was only armed with a knife. He did not take any of these actions at any point during the considerable ride to Willow Point. At the destination, he complied with the one-legged man's directions, despite the fact that the one-legged man made no threats. After leaving the one-legged man with the dying victim, he made no immediate effort to report the victim's whereabouts to obtain emergency medical treatment. Before going home, he went to a friend's house and changed clothing, discarding his own. Then he went without reporting the victim's condition or location. And when he went to the police station to report the crime, only after arriving home and discussing the matter with his mother. So they're like, okay, from this, we can basically say, yeah, you aided a felon, right, to avoid arrest, or you helped dump the body. It was your intent purposefully to aid the felon and to avoid arrest, prosecution, or conviction, or you were all but certain that your actions would result in the felon avoiding arrest, prosecution, or conviction. So what ultimately happens is the Supreme Court of Louisiana upholds the conviction, but vacates the sentence because the sentence imposed by the trial judge was illegal. The judge imposed a sentence of 3 years. He suspended 2.5 years of the term. The trial judge has no authority to suspend parts of sentence in a felony case. The correct sentence would have been a suspension of all 3 years of the term, with 6-month term as a condition of 2 years probation. So they vacated the sentence and they remanded the case for resentencing. All right. So again, here, this is more than just knowledge, right? I mean, you have to look at the circumstances. You have to look at everything that's present at the scene, the context, etc. In this case, you have the one-legged man, right? Like, yeah, he just stabbed somebody, like, but you could run because he has one leg. And at some point he loses the leg. Like, what's he gonna do? If you get out of the car, he only has one leg. Like, he's gonna be restricted to what he can touch on the vehicle to hold himself up. Unless he's like really good at hopping. So, right, this may have been a different outcome if we didn't have the one-legged man, because you could talk about being in fear, and you could always raise affirmative defenses of like, yes, I helped, but it was out of fear or whatever, because yeah, he was armed, right? The one-legged man was armed, but he only had a knife. And if you had 2 legs and you could run, well, maybe a knife would be considerably more dangerous than a knife by a one-legged man who definitely has the odds stacked against him. So the thing that stands out to me in this case is we don't know what happens to the leg. Like, we don't know if it falls off when he stabs her. We don't know where the leg gets lost, but we just know that the leg just disappears at some point. So again, we have people, we have potentially transgender, we have potentially different gender identity, we have a one-legged man. Like, this is an awesome case. If you haven't read it, I encourage you to do so. It is testable, but it's also just a fascinating case to read, because you're like, wait, the one-legged man did all this crap and you guys didn't do anything? Like, yeah, you're obviously accessories, right? And there's actually even a question that gets raised here is when they stop and change clothes at the friend's house, and then by the time the police get to the friend's house, the clothes have disappeared. Are the friends now accessories? Right? And probably, yeah. Because if you're covered in blood, you probably are aiding a felon to avoid arrest, prosecution. And if you don't do anything about it and you destroy the clothes, it's probably your purpose to help your friend out to avoid arrest, prosecution, or conviction. So that being said, I do have one question to let you just kind of think of and just kind of mull over. And that is defense lawyers. Are defense lawyers accessories after the fact? Well, think about it. Let's look at the actus reus. Defense lawyers, if you are appointed counsel for somebody who's convicted of a felony, is it your actus reus, or your actions? Are you aiding a felon to avoid arrest? Well, probably not, because they've already been arrested. Prosecution, well, they're being prosecuted. That's why you got. That's why you got appointed. Or conviction. And so, are we aiding a felon to avoid conviction? And then the mens rea comes into play. Is it your purpose, or are you all but certain that your actions are designed in such a way that it would help aid a felon in avoiding a conviction? And of course, any other attendant circumstances. Right, so your kind of initial jerk reaction is like, well, it seems that way, right? And there's actually a lot of jurisprudence on this, or at least scholarly works, I should say, on this concept. And some say yes, some say no, but generally we give a pass for it because it's necessary for justice. The role of a lawyer is not to help you avoid conviction, right? Theoretically, the role of a lawyer, the role is to advocate for your client and to let the truth prevail. Now that's just theory, right? And I mean, reality, like you're trying to help your client not get convicted. But that being said, you can't take affirmative steps to hide evidence. So let's say that your client comes to you and is like, oh yeah, the gun is buried under the porch. You as the defense attorney can't go then under the porch, dig up the gun and dispose of it, right? Because at that point, you've crossed the line into helping them avoid conviction or what else or whatever. It's interesting. In fact, defense attorneys do have an affirmative duty to report crime to a degree that their clients come to them and confess to. So you go see your attorney, it's an emergency, you've just stabbed somebody, they're bleeding at home, you go to your attorney, you're like, I just stabbed somebody, what do I do? The attorney's going to ask you, like, are they alive, are they dead, what's going on here? And the attorney has to call the police, and the attorney cannot mention the name, cannot mention the person who came to them, cannot mention that somebody did come to them, cannot mention really anything. All they can do is call 911 and say there's a person bleeding at so-and-so address, right? That's going to be pretty clear, like who came to them and all that jazz. But there is that confidentiality, but we also want attorneys to do the right thing and preserve life if at all possible. So again, we've talked about vicarious liability a little bit. So vicarious liability, what it does is it transfers the actus reus and the mens rea from one person to another, or from one or more persons to an enterprise because of their relationship. So that being said, we have two types of vicarious liability. There's corporate vicarious liability. This is kind of on the doctrine of respondent superior. And then we have individual vicarious liability. So we're talking about corporate vicarious liability. We have really good case on point, New York Central and Hudson River Railroad Company v. United States. And this is this idea, and what it stands for is that corporations can commit crimes based upon the doctrine of respondent superior. In other words, in response to the master, in which corporation employees' acts are imputed to the corporation. So if you want to take a look at a case and you want to have a little bit of a college life, look at State versus Zeta Chi fraternity. It's a 1997 case. So this case involves the sale of alcohol to minors and prostitutes and all kinds of just wow stuff. So I'll just read you the facts and then we can kind of discuss the case a little bit. So Zeta Chi, a New Hampshire corporation and fraternity at the University of New Hampshire in Durham, held a rush at its fraternity house to attract new members. In order to encourage people to attend the rush, Zeta Chi hired 2 female strippers to perform at the event. Fraternity brothers encouraged guests to give the strippers dollar bills so they would continue to perform. The brothers also told guests that the more money the strippers were given, the more they would do. One of the members of the fraternity was providing change for larger bills. As a part of the performance, the dancers lay on a mattress brought out by members of the fraternity and simulated oral sex on each other. At one point, a guest gave $5 to one of the strippers who sat on the guest's lap. When a brother moved the dancer along, the guest complained that he had given $5. The stripper took the guest to the mattress and pushed his head into her crotch. 2 witnesses testified at trial that they saw the guest being led to the mattress after they gave money, at which point the guest then performed oral sex on the dancer. In addition, Andrew Stanton, a 19-year-old guest at the fraternity party, testified that at some point during the evening, he learned that beer was available from a soda machine. He made his way to an apartment in another part of the fraternity house where the machine was located, waited in line with 3 or 4 other people, and purchased 3 to 5 cans of beer. Stratton also testified that he noticed someone making change for the machine. The fraternity's secretary testified that the fraternity members voted not to provide alcohol at Rush and that they moved the vending machine that contained the beer to a separate apartment in part of the fraternity house for the rush. He also testified, however, that the fraternity had control over the vending machine and its proceeds, and that only fraternity members would have an interest in making change for the machine. So ultimately what happens, right, is the defendant, the college fraternity, is convicted following trial of selling alcohol to a person under the age of 21 and prostitution. Right, so because of what the brothers of the fraternity did, right, the question is, are they acting as employees, or are they acting as agents of the fraternity? When they were committing their nefarious acts. The court ultimately holds that a corporation is not insulated from criminal liability merely because it published instructions and policies which are violated by its employees. The corporation must place acts outside the scope of an employee's employment by adequately enforcing its rules. So ultimately, the court upholds the conviction of the fraternity, not fraternity members, but the fraternity, the corporation, for prostitution and selling alcohol to a minor. And that being said, you can't put a corporation in prison, but you can fine them. right? You can find them. You can take away corporate charters. You can do all kinds of other things to a business under this idea of respondent superior. Now, that being said, this case shows us that not every vicarious liability incident involves federal cases against huge corporations, right? Individuals are vicariously liable for their agents' actions in state cases, and most don't attract our attention. Most common cases are employee crimes committed within the scope of their employment, but without the approval or knowledge of their employer, right? So that transitions to a different type of vicarious liability, which is individual vicarious liability. Now, this usually stems from a statute on the basis of a special relationship. And it differs from parental responsibility statutes, which based on parental acts and omissions in terms of what a child does and doesn't do. So you have Bowen, who basically engaged broken ordinance that makes it illegal for anyone who holds a liquor license or one of his or her employees to serve alcohol to anyone not of age. So basically in this case, the defendant owned Fox Run Lanes, held a liquor license for the establishment. One of the bartenders he employed sold a beer to an underage volunteer participating in a sting operation conducted by the local police department. As the owner was not present at the time of the sale, however, police cited the owner, so gave him a citation, and not the bartender for serving the underage person under this code. The city has a policy of always citing the business owner as opposed to his or her employees when enforcing the law. So ultimately what happens is it goes up through the appellate courts, right? I mean, and ultimately the appellate court affirms the judgment, right? And basically they say the law contemplates liability for either the person holding the liquor license or of his or her employees. The language indicates that the ordinance considers both bar owners and their employees as potential violators. While the ordinance does not explicitly say bar owners are liable for the actions of their employees, we see nothing to indicate that an employer should be insulated from the illegal conduct of his or her staff in situations like this one. So they uphold the conviction. All right, so again, we have a really kind of interesting case where you have an employee, even though the person isn't present, but the simple fact, because they own a liquor license, because they have a liquor license, there's all kinds of restrictions that get placed on you when you have a liquor license to follow the law. And doing so, right, there becomes a really big issue. Because a bartender sells somebody underage. And even though you're not there, you weren't on the premises, you still own the building, and because of it, you're responsible for the actions of your employees. Right, and then we also have State v. Akers. In this case, parents were found guilty of violating a snowmobile statute, which makes parents vicariously liable for the acts of their children simply because they occupy the status of parents. So the parents waived all right to an appeal de novo or a new trial to the Superior Court. Parents objected to the constitutionality of the parental responsibility snowmobiling statute. So basically what happens is the parents, the defendants, are a father whose minor sons were found guilty of driving a snowmobile in violation of the laws of New Hampshire, which pertains to the operation and licensing of off-highway recreational vehicles, provided that, quote, the parents or guardians or persons assuming responsibility will be responsible for any damage incurred or for any violation of this chapter by any person under the age of 18. Right, so ultimately, the children violate the statute. The dad gets held responsible under the statute, gets found guilty, and seeks to appeal the case and make an argument in which they're saying, look, it wasn't intended to impose criminal liability, it was intended to impose civil liability. But if it was intended to impose criminal liability, it violates the Constitution of New Hampshire as well as the US Constitution. Ultimately, the court notes that without passing upon the validity of statutes that might seek to impose vicarious criminal liability on the parts of employers for acts of his or of his employees, we have no hesitancy in holding that any attempt to impose such liability on parents simply because they occupy the status of parents without more offends the due process clause of our state constitution. Parenthood lies at the very foundation of civilization. The continuance of the human race is entirely dependent upon it. It was some firmly enhanced Judeo-Christian ethic when, in the beginning, man was commanded to be fruitful and multiply. Considering the nature of parenthood, we are convinced that the status of parenthood cannot be made a crime. This, however, is the effect of the statute. Even if the parents had been involved or had carefully, or excuse me, even if the parent has been careful as anyone could be, even if the parent has forbidden the conduct, and even if the parent is justifiably unaware of the activities of the child, criminal liability is still imposed under the wording of the statute. There's no other basis for criminal responsibility other than the fact that a person is the parent of one who violates the law. 127 years ago, the justices of this court, in giving their opinions regarding a proposed law that would have imposed vicarious criminal liability on an employer for acts of his employee, stated, but this does not seem to be in accordance with the spirit of the Constitution. Because of the net effect of the statute is to punish parenthood, the result is a forbidden violation of the due process clause of the New Hampshire Constitution, and the conviction ultimately gets reversed. But there's a really good dissenting opinion, and the dissenting opinion basically makes the argument of like, a parental conviction, so a parental conviction can result only when the state shows beyond a reasonable doubt that the minor child has committed a violation under the provision of the law, and the parent voluntarily performed or omitted to perform an act such as participating in the minor's conduct or entrusting or negligently allowing the minor to operate the vehicle. Right. So this said that this is a public welfare offense, and therefore it doesn't require any criminal intent. So this is a strict liability offense, and constitutional and is in holding and is in line with the U.S. Constitution, right? And so ultimately, that is the defense, or excuse me, the dissent. So it raises interesting things, and the question really has never been settled as to whether you can say that, well, your child committed the crime, so you're responsible. But there's really, if you can make the argument, there's really no big difference between bone and acres, right? You have somebody who wasn't there, who probably forbade the practice of serving underage because they had a liquor license and all that jazz. We also have parents who probably forbade the practice of operating the vehicle because they had kids and they didn't want to be held responsible under the statute. So one thing to keep in mind is both these cases are state cases, Wisconsin appellate court case and then a New Hampshire Supreme Court case. None of these cases have been firmly resolved by the U.S. Supreme Court. Instead, these are the laws as applicable in each state as it stands today, unless there has been subsequent case law since the publishing of this textbook. So that being said, the next class, we are going to talk about the crime of attempt. As always, if you have any questions, comments, or concerns, please do not hesitate to reach out to me, and I'll be more than happy to talk to you.